Council?
Yes, Council, I've joined.
Thank you very much, Esther. Good morning, honorable judges.
Good morning, CJ. DCJ. Good morning.
Good morning, DCA Council.
Good morning, Jay.
The Supreme Court for the inaugural hearing session by our new Chief Justice and our new colleague. We have a brief session to go through just before we start the main hearings for today. And it is my honor to invite Council to address the court. And we shall proceed in the following manner. Senior Counsel Dr. Fred Ojambo, you will speak both your senior counsel team and whatever other brief you may have. Welcome, Dr. Senior Counsel Fred Ojambo.
Thank you very much, Honorable Sister Jay. May it please you,
Counsel, you're muted.
I beg your pardon, my lady. I may please you, the court, the Honorable Lady Justice Martha Karumba Koome, Chief Justice and President of this Honorable Supreme Court of Kenya, my lady, the Deputy Chief Justice and Vice President, the Honorable Lady Justice Philomena Mbetne Mwilu, my lady and my lords, Justices of the Supreme Court. For the record, my name is Fred Ojambo, and today I appear in these proceedings on behalf of the Senior Counsel Bar. And in that capacity, I take this opportunity to congratulate Your Ladyship, the Chief Justice, and my lords, the Honorable Mr. Justice William Oko, on the occasion of your first sitting as judges, and in the case of the Chief Justice, the President of the Apex Court of this Republic. Your Ladyship was appointed to this high position and the office of Chief Justice on the 21st of May, 2021. Your Ladyship's assumption of this mantle could not have been at a more significant time. Yours is the highest constitutional court, and for the first time in the history of our young nation, its president is a woman. That, in my humble submission, is no mean achievement by you, my lady. But it is far more than that, for it speaks not only to the liberating drive of the people of this nation to plumb new horizons, but also, and remarkably so, to their tenacious determination against the subjugation and suffocation of past phobias about gender parity. Further, your ladyship's accession to this high seat is much more nuanced than that. This year, the country celebrates the first decade of the Constitution, which was promulgated on the 27th of August, 2010. As the Constitution enters its second decade, for a variety of reasons and on diverse grounds, much attention is beginning to be focused on its sufficiency or appropriateness, as the foundation for a progressive and vibrant developing society. While some voices are agitating for its responsiveness to current realities and future efficacy, others are a strident call in favor of its immutability. In the resulting deafening cacophony, it is confusing as to whether the contests are a comedy or a tragedy of the rule of law and the administration of justice. Upon this highest court in the land lies the awesome and onerous responsibility of making sense of this rootlessness. Never before in its young existence has this court been confronted by such sharp, divergent public expectations for it. Nor, if I may suggest, has such a heavy enterprise been thrust so brusquely upon this honorable court. This court, Honorable Chief Justice, under your leadership, will be called upon to break new ground in the constitutional jurisprudence of this country. There will be public pressure for the court to either apply the route of dominant opinions or authority on the one hand, or parrot majority in the name of the public good on the other. Yet, upon it, will there be no greater duty than to do justice without fear or favor, affection or ill will in an increasingly toxic social milieu. My Lady Chief Justice, and my lords and ladies justices of this honorable court, we pray that you shall remain true to your calling, notwithstanding the circumstances. You shall eschew any invitation to do the convenient or the expedient, or to drift subtly away from the basic premise and essential thrust of your sworn duty, which is to the dictates of justice and justice alone. And in your discharge of that solemn task, the senior bar will stand at all times ready to be of assistance. We hold strongly to the view that the ultimate fulcrum of the stability of any nation is its fidelity to the rule of law, the centerpiece of which is an independent and principled judiciary. And to the support of such an institution, we shall pledge our boundless loyalty, and along with it, we shall be honored to serve this republic. I therefore close, if I may, my Lady Chief Justice and my honorable judges of this Supreme Court of this great Republic of Kenya, with a stirring injunction immortalized for us in Scripture in the book of Deuteronomy, chapter 16, verse 19 to 20, and I quote, "Do not pervert justice or show partiality. Do not accept a bribe, for a bribe blinds the eye of the wise and twists the words of the innocent. Follow justice and justice alone, so that you may live and possess the land the Lord your God is giving you." That is Deuteronomy chapter 16, verse 19 to 20. And so, Honorable Chief Justice, my ladies and lords of the Supreme Court, may it be for all of you. Thank you.
Thank you very much, Senior Counsel. And thank you for those very apt words to not just the Chief Justice, but to all of us on the court. It's my duty now, I think, first to report that the Registrar of the Court advises me that the President of the Law Society of Kenya, Mr. Nelson Harvey, has sent his apologies, he would have been the next person to address the court. It now is my honor to call upon Mr. Alex Mutembei, representing the Director of Public Prosecutions, to address the court.
Thank you, my Deputy Chief Justice. Your Lordship, the Honorable Chief Justice, and your Lordships present. Let me take this opportunity on behalf of the DPP to first congratulate the Honorable Chief Justice for our elevation to the position of Chief Justice at a time when the world expects gender equity and is looking forward to world leadership in that area. Indeed, my Lady Chief Justice, as an office, we are grateful that from the process that you went through, the Judicial Service Commission, in its wisdom, picked one of its own for elevation to the position of Chief Justice. This we say because it is a recognition of the important role that the judiciary plays in our country, and it by no means confirms that you as a judge has made invaluable contribution, and therefore the appointing authority considered it necessary to appoint you to this position. Having said that, I wish to confirm that as an office, we will endeavor to pursue interagency cooperation and collaboration in the delivery of justice, not only to victims of crime, but also persons charged with criminal offenses. We offer our unequivocal confirmation that at any one time that the judiciary shall consider it necessary, as an office, we will be available for any contribution that we can make to improve our systems and ensure that justice is delivered to all timelessly. We embrace your leadership, knowing and noting that during the period that you served in the civil society, Honorable Chief Justice, you emerged as one of the champions of the protector of human rights. You did not shy away from controversy whenever duty called upon you to address the question of justice. And in so doing, you made serious and considered contribution to the development of our law. Let me take this opportunity and note your invaluable contribution in the decision of the Attorney General versus Mohamed Ashie and others, where as a court, with the former Chief Justice, the Emeritus D.K. Moraga and others, you did actually confirm the applicability of international law in our jurisdiction. That by itself is confirmation that indeed, as a Chief Justice, as you begin your journey in that office, we can look forward to decisions that will not only take into account the local jurisprudence that we have developed in several areas, but also international best practice that indeed as a country we require so much in many areas. This is particularly important to us because as an office, we are confronted with emerging crimes that have assumed international dimension. And if we were to limit ourselves to local jurisprudence, then obviously we would suffer very serious shortcomings in terms of delivery of justice. That is a commendable position that Honorable Chief Justice and the rest of the judges who sat in that matter really took. And we believe this being the highest court, then you shall be leading from the front in adopting international best practice as you interpret our law. Allow me, my Lady Chief Justice, and your lordships present, to also make reference to yet another decision that we consider of jurisprudential importance as an office. In the case of Veronica Gitai, Inspector Veronica Gitai and another, a decision that my Lady Chief Justice, you rendered in Malindi together with the Honorable Justice William Ouko, with whom we also take serious note that you have been elevated at the same time to the Supreme Court. You did come out very strongly in that decision and affirmed that human rights should be protected of the lesser mortals in society. I choose the words lesser mortals not because of lack of better words, but this being a matter where a young girl was murdered by officers that were indeed charged with protection of that very person, you did not shy away as a court to uphold the decision of the High Court, and you consigned those officers to the fate that they chose. Having said that, allow me to end by saying the following, that notwithstanding the fact that the judiciary is independent, the three arms of government remain interdependent, and throughout your term as Chief Justice, we promise we shall be available to render support where necessary without compromising on your responsibility and the responsibility of the other two arms of government, so that the best results that we can achieve as a system, we are able to achieve them. And with those few remarks, Honorable Chief Justice and my Lady Deputy Chief Justice and your lordships seated together, we look forward to a very robust Supreme Court that shall continue to provide guidance even as we proceed to the next dispensation, which definitely, of course, everybody knows, in the next 1 year, we will be dealing with very germane issues related to elections, and justice will be one of the key things that everybody will be looking up to. Thank you very much for the invitation. I rest my submission.
Thank you, Councillor Alex Muteti. Thank you for sharing your wisdom with our Chief Justice. Thank you for promising that interagency cooperation is going to be enhanced by yourselves during, and I suppose always, but during the tenure of our current Chief Justice. Thank you for your promise that you undertake to improve the justice chain system, guided by what Senior Counsel Fred Ojambo said, that we shall continue to remember that ours is to follow justice and justice alone. Thank you, Mr. Muteti. It's now
Thank
my
you, my lady.
turn to invite our brother from the Attorney General's office, Mr. Kennedy Ogeto, to speak to the Chief Justice and to speak to us. Mr. Ogeto.
Thank you very much, Honorable Deputy Chief Justice, and good morning.
Good morning.
My lady, the Chief Justice and President of the Supreme Court, my lady, the Deputy Chief Justice, my lords and my ladies, judges of the Supreme Court, the Director of Public Prosecutions, presented by Mr. Muteti, ladies and gentlemen, well, let me also acknowledge Dr. Fred Ojambo, Chair of the Senior Counsel Bar. Ladies and gentlemen, I'm very grateful this morning for the honor and opportunity to make these brief remarks during this very auspicious occasion. I'm in attendance today on behalf of the Honorable the Attorney General. He would have wished to attend this event, save for other urgent official business that demanded his personal attention. He has requested that I convey his humble apologies. My lady, the Chief Justice, may I take this opportunity to once again congratulate you on your assumption of office. May I also take this opportunity to congratulate our brother, Justice William Ouko, on his new role as a judge of the Supreme Court. Kenyans and the world look up to you and your colleagues in this court to answer to the call of justice. They expect that the Supreme Court, and indeed all our courts, shall remain true to the duty as the temples of justice. My lady, the Chief Justice, the commencement of your role as the Chief Justice and President of this court has come at a very critical time in the development of our justice system. During the last year, we have witnessed significant adoption of technology in our court system. We look up to your leadership to harness the benefits that have come with this new approach and to ensure that no part of the country is left behind in this regard. Lady the Chief Justice, as we advance economically, socially, and politically, we also continue to face unprecedented questions and challenges that require the guidance of our courts. This court, as the apex court, has the sacrosanct opportunity to shape and enrich our legal development, perhaps for generations to come. Such legal development is not just for the people of Kenya, it is also for the region and in some instances, the world at large. This is, without a doubt, a heavy and monumental task. We remain confident, however, in this court's ability, under your able leadership, to guide the nation in the direction of law and justice. We must continue to strive to be a country of the rule of law and not of the rule by law. My lady, the Honorable the Chief Justice, may I, at this juncture, take this opportunity to wish you the very best. May God and the court, and may God bless Kenya. Thank you, my lords and my ladies.
Thank you very much, Council Mr. Ogeto. Thank you for those words, and we shall remember that our duty is to shape the legal direction of the dispensation of justice. We shall remember to answer only to the call of justice and nothing else. And we shall remember that in you, we have a valued partner. Thank you very much. At this juncture, it's my duty, honor, and privilege to invite the Honorable the Chief Justice of the Republic of Kenya, who is the President of this court, to address not just the three speakers, and not just to react to those, but to speak to the justice chain that waits for direction on matters justice from the Honorable the Chief Justice. Chief Justice Mother Koome.
Thank you very much, my lady, the Honorable Deputy Chief Justice, my colleagues, judges of the Supreme Court, all senior counsel present, led by the chair, Dr. Friend Ojiambo, the Solicitor General, Mr. Ken Ogeto, Mr. Alex Muteti, representing the DPP, and all council present, guests, ladies and gentlemen, good morning.
Good morning.
Good morning.
It is the first time I and my brother, Mr. Justice William Ouko, are wearing this prestigious robe of the Supreme Court. For me, I do so with grace and gratitude to God and to the people of Kenya who made it possible for me to ascend to this office of the Chief Justice and the President of the Supreme Court. In this capacity, I extend my appreciation and gratitude to everyone represented here today, the various actors in the administration of justice and state organs, learned counsel, members of the public, and the court staff who have joined us for this inaugural sitting of the Supreme Court following the court's recent constitution when I and my brother, Mr. Justice William Ouko, joined the court. I would like to thank my brother and sister judges of the Supreme Court, and I also recognize the retired judges who worked tirelessly over the past decade to position the Supreme Court of Kenya as a respected and admired court in the globe. It is worth mentioning that the court's indigenous jurisprudence in areas like the electoral law, human rights, especially where the court determined questions on the mandatory death penalty and the right to housing, are profound pronouncements. The workings of the devolved system of government and the practice of bicameralism in our legislative system are decisions of this court that are being cited and talked about with admiration by scholars and nationally and internationally. Our focus will be to build on this very strong foundation in the next decade. There is no doubt that the adoption of the current constitution is the most consequential event, as Senior Counsel and Dr. Fred Ojiambo has reminded us, and it provides a progressive pillar for Kenyan law. It also has a comprehensive guiding compass for Kenya in the next decade. There is no doubt that the adoption of the current constitution is the most consequential event, as Senior Counsel and Dr. Fred Ojiambo has reminded us, and it provides a progressive pillar for Kenyan.
My lady CJ, just a minute there. Esther, the technical team.
Sorry about that.
Yeah, get us. My lady, just wait, please. Esther, Wamoto.
We are there. Thank you.
Are we back?
Looking into
Yes. CJ, kindly unmute.
I can proceed.
Now you can, my lady.
Thank you, and sorry for that interruption. The Constitution stands as the most progressive pillar for Kenyan law and as a comprehensive guiding compass for Kenya's internal organization and global posturing. It must be appreciated that our Constitution, in its values, principles, and rules, reflects the desire by Kenyans to break with our past, authoritarian governance and unequal society, and to strike in a radically different path of creating a democratic and egalitarian state and society. It is the foremost manual on the creation and sustenance of a welfare state, meeting the needs of the Kenyans wherever they are. Our Constitution reflects the kind of society that Kenyans wish to build for themselves and for future generations. It reflects a desire by Kenyans to build a socially just society and a just state. This is a bold pronouncement of the aspirations and purposes that should animate all actions by state and non-state actors. Thus, for us in the Supreme Court and other courts, the development of a jurisprudence of social justice, or put differently, a social justice jurisprudence, will be our guiding North Star in the next decade. In essence, our role will be to guide other courts to broaden the administration of justice in a manner that is owned by Kenyans, socially transformative and empowering our communities. The pronouncement in the preambular provisions of the Constitution, Article 10 on the values and principles of national governance, Article 19.2 on the purpose of the Bill of Rights, reads to the inescapable conclusion that the Constitution is indeed a charter for social transformation. Given that the Supreme Court is the final custodian and guarantor of this Constitution, it is the court that should always endeavor to provide jurisprudential leadership to the country in the quest for transformation of the society using the Constitution as the tool of social change. We will seek to put in practice the instruction with the command in Article 23 and 259 of the Constitution, and also our Section 3 of the Supreme Court Act that requires that courts should develop the law to ensure that the vision of the Constitution is realized. This court, in its operations and functioning, will place a premium on collegiality and civility. By emphasizing on collegiality, I mean that as judges, we are working on a joint project of deciding the matters before us impartially and independently to clarify the law. Thus, the need for sharing of ideas and enriching our perspectives to resolve the disputes before us. This, of course, does not mean that difference of opinion is not encouraged. Rather, it means that judges have a duty to disagree in a principled manner. Recognizing that ours is an adversarial legal system that tends to pit parties against each other, it tends to encourage hostility and often leads to uncivil attacks directed to judges and to counsel on the opposite side. Such a situation, I dare say, weakens public confidence in the judicial process. My expectation is that the bar, while having the leeway and indeed encouraged to engage robustly and skillfully before us, we will appreciate the importance of civility from the bar. Thus, where one has a different opinion, it will be expressed in a manner that respects the adage of, I quote, disagreeing without being disagreeable, end of quote. We will call upon the public, the council, and everybody to allow judges to decide matters based on substantive issues before them, and not to divert the time and effort to some side shows who are meant to cross the line and disrespect the court of the court. It will also be the court's duty to settle monumental and troubled questions of law affecting the society and to seek to intervene to ensure that justice system is operating effectively as intended by the Constitution and our laws. Towards this end, the court is sitting today to issue directions with respect to the implications of the landmark decision by the Supreme Court in the case of Francis Muruateto, popularly known as the Muruateto case, which will be for the smooth and efficient operations of clarifying the sentencing in our criminal justice system. The Muruateto case is a landmark decision in our human rights jurisprudence. The Supreme Court held that sentencing is a judicial and not a legislative function under the principle of separation of powers that underpins our constitutional order. Since there may be varying degrees of criminal culpability, participation, heinousness, we all know not all murders are the same, and thus the need for mitigation in our murder trials, and indeed in capital offenses where the accused person is facing a death sentence. Therefore, it is improper to impose one sentence by the legislature applied by the courts. the mandatory death penalty is constitutional, but the mandatory nature of the sentence is what was found to be unconstitutional. And hence that case was referred for resentencing. The decision is undoubtedly a landmark for sentencing policy in Kenya and a good example of the impact of the Bill of Rights of punishment in criminal justice. It reiterates that constitutional punishment, the imposition of punishment for crimes. While Murwateto obviously was limited to the death penalty in murder cases, the principles have been used and pronounced and have had far-reaching implications with ramifications for sentencing in other cases. Hence the need for this court to give further directions. Indeed, the Court of Appeal and the High Court extended these principles to other cases, i.e. robbery with violence and other criminal cases where legislation prescribes minimum and mandatory sentences. And this is the situation that we intend to clarify today in the directions. While the principles of Murwateto have been argued that are transferable, and this is a live debate, these cases have not yet been brought to this court to interrogate and to determine. This is a live controversy which will be resolved at an appropriate time when such cases reach the Supreme Court through the usual process. It is noteworthy that the Supreme Court in the Murwateto case directed the Attorney General, the Director of Public Prosecution, and other relevant agencies to prepare a detailed professional review within the context of the judgment and set a framework to deal with the sentence, the hearing of cases of people who are sentenced to death. And the Attorney General was given 12 months to do that exercise. Unfortunately, it took long. And it is pursuant to those orders. After the Supreme Court received the report by the task force that was put together by the AG, that these directions were prepared. The aim of the directions and post-judgment hearing that we are doing today is to enable the court to get a report which we have received on the development of a framework for resentencing hearing and any difficulties that has been faced in the implementation of the judgment so that the Supreme Court can offer appropriate direction and orders that will ensure the criminal justice system works optimally. As a matter of priority, upon giving these directions, I intend to consult with the Attorney General and other actors and stakeholders in the criminal justice system to put together a committee on revising the sentencing guidelines in line with these directions. Lastly, it would be remiss to conclude without mentioning and expressing my gratitude to the judges and staff of this court, and indeed all judicial officers and staff of the judiciary for the hard work they have put to ensure that our courts are running since the pandemic struck this country this year. We were considering holding this inaugural sitting in an open court, but we did this so as to encourage online proceedings and to recognize that the pandemic has changed the way the Supreme Court and other courts have been operating. We have now embraced technology, and we are not letting it go because it eases the way we conduct our business. It has forced us to accelerate and embrace the information technology in our operations. The Supreme Court has embraced video and remote hearing to ensure that delivery of justice does not stop. I therefore thank the court staff, judges, and the bar for enthusiastically supporting us and embracing the changes, even as we work to resolve the teething problems of e-filing and other challenges that we experience in ensuring that we render justice during this difficult time. On that note, I wish to assure Kenyans that the Supreme Court and its judges do not live in ivory towers. We understand the problems that each one of us is encountering to access justice, as we are part of the Kenyan society. And we will ensure that we give our best to nurture the social transformation that the Constitution has imposed on us. But as judges, we will remain independent and impartial as directed by the Constitution. And we urge Kenyans to allow us to speak through our judgments and not to respond to matters that are not before us. I thank you, my lords, my lady judges, all the colleagues, and everybody for listening. Thank you very much.
Thank you very much, Honorable Chief Justice. Now guided that this court shall heed the exhortation in the Bible that says that we shall follow justice and justice alone. Listening to the promise that we shall get cooperation from the office of the DPP, and that there shall be an endeavor to improve the justice system chain. Thank you, Solicitor General, for telling us to answer to the call of justice and to the call of justice alone. Ready as we have always been in this court to do the right thing, having heard the Honorable the Chief Justice, we promise that we shall do what we know we came here to do, and which shall be to follow justice and justice alone. Thank you very much for coming and listening to the Honorable the Chief Justice. And it is now my pleasure to announce that Dr. Fred Ojiambo, Mr. Alex Muteti, and Solicitor General Kennedy Ogeto, you are free to log out, but you're also free to sit in and listen to the hearings that are proceeding immediately after this. And I now call upon the court administrator to call out for directions, the first matter on the course list. Thank you very much.
Much
Thank you.
Most obliged.
Thank you. Thank you, Honorable DCJ. The first matter coming up this morning in the course list for directions is petition number 15 and 16 of 2015. Francis Karioko Murwatetu and another versus the Republic. I request counsel to kindly introduce themselves to the court.
Counsel appearing in the matter of Murwatetu, please introduce yourselves to the court. Anyone present for the case of Murwatetu?
May it please you, my lady. My name is Miss Christine Konge for Katiba Institute, which is one of the 5 amici that was joined in this matter.
Welcome, Konge.
May it please your ladyship, my lady, my name is Tabitha Uya, representing the DPP.
Welcome, Tabitha. And may I ask that anyone who is not addressing the court please remain muted? Tabitha, please check whether that noise is from your end. Thank you very much. Any other counsel in the matter?
May it please your ladyship, my name is Emmanuel Vita. I appear for the Attorney General in the matter.
Welcome, Vita. Anyone else? Any other representations? There being none, and I thought I saw, or did I see my own things? I thought I saw the parties or one of the parties in court.
Yes, Honorable DCJ, we have both the petitioners present in court virtually, but we also served advocates who are representing them.
Honorable DCJ.
Yes, please.
Professor Ojenda is holding brief for Fred Nkatia.
Yes, please.
And he's having difficulties in joining the link. We are trying to get him.
All right. And Kevin, the petitioners can hear and see us?
My lady.
Yes, please.
Lady, I can hear you. My name is Francis Rioko. I'm a committee petition.
Welcome, Mr. Murwatetu. The Honorable, the President of the Court, the and parties eyes up. Esther, can we please control this background? To find the source, please. Thank you, and keep it that way. Judge President of the Court, it's now called my lady President. Esther, please.
Oh, I'm looking into it, Honorable DCJ.
Thank you, Esther.
Thank you, Marede. Good morning.
My lady CJ, just give us a few minutes. We just can't seem to sort this noise. Esther, are we good to go?
Yes, we're okay now. They've muted.
Thank you so very much. Judge President.
Thank you, Marede, Deputy Chief Justice, my lady justices Joki, my brother judges, and all present in court, including the two petitioners, counsel, good morning.
Good morning.
Good morning.
These are the directions of the court pursuant to the orders that were made that the matter be mentioned for further directions. And I will read on behalf of all the judges, the entire court. It is common that this appeal specifically involved two petitioners, Francis Murwateto and Wilson Mwangi, whose conviction and sentence of death for the offense of murder, contrary to section 203, as read with 204 of the Penal Code, was upheld by the Court of Appeal on a past appeal. All the two petitioners challenged before this court was not their conviction, but the mandatory nature of the death sentence imposed on them by the High Court and affirmed by the Court of Appeal, and were arguing that it was inconsistent with the Constitution and therefore void. Two other issues were raised: whether the indeterminate nature of a life sentence is also inconsistent with the Constitution, and whether the court ought to assign a different definite number of years of imprisonment subject to remission rules, which will constitute a life imprisonment. In considering these questions, the court confined its determination to the following issues. One, whether the mandatory nature of the death penalty under section 204 of the Penal Code is contrary to the Constitution. Two, whether the indeterminate life sentence was equally unconstitutional. And lastly, whether this court ought to define the parameters of life sentence. By a judgment rendered on 14th December 2017, this court, differently constituted, readily accepted that the last two questions, that is 2 and 3, not having been canvassed before the two courts below, were not available for the court's determination. Those are the questions about life sentence. On the first question, however, the court made the following declarations and orders, which I will read. One, the mandatory nature of the death sentence as provided for under section 204 of the Penal Code is hereby declared unconstitutional. For the avoidance of doubt, this order does not, and I emphasize, does not disturb the validity of the death sentence as contemplated under Article 26(3) of the Constitution. Two, this matter is hereby remitted to the High Court for the hearing on sentence only on a priority basis and in conformity with this judgment. Three, the Attorney General, the Director of Public Prosecutions, and other relevant agencies shall prepare a detailed professional review in the context of this judgment and order made with a view to setting up a framework to deal with the sentence hearing cases similar to that of the petitioner. Please mute. The Attorney General is hereby granted 12 months from the date of this judgment to give a progressive report to this court on the same. And 4, we direct that the judgment be placed before the speakers of the National Assembly and the Senate, the Attorney General and the Kenya Law Reform Commission, attended with a signal of the utmost urgency for any necessary amendments, formulation, and enactment of statute law to give effect to this judgment on the mandatory nature of the death sentence and the parameters of what ought to constitute life sentence. Despite the AG, the DPP, and other relevant agencies having 12 months within which to present a progressive report on the framework proposed to deal with sentence rehearing of cases similar to this, that report was not filed until 11th October 2019. At that point, the attention of the court to the by lack of sentencing guidelines. He pleaded that there was need to have the guidelines issued promptly to address the numerous pending applications, petitions, and appeals on resentencing. On this part, Mr. Ochiel, learned counsel for Katiba Institute, expressed concern that the delay occasioned by the AG in filing the status report had resulted in the ability for the courts to ascertain whether or not its judgment was being complied with. It had compounded the violations of the appellant's constitutional rights and the absence of anticipated guidelines and created inconsistency, confusion, and uncertainty within this aspect of criminal justice. The appellants, on the other hand, confirmed that contrary to the orders of the court, they had not been afforded up until that time a resentencing hearing by the court. In the meantime, it is public knowledge, and taking judicial notice, we do agree with the observations of both Mr. Asen and Mr. Ochiel that while the report of the task force appointed by the AG was awaited, courts below us have embarked on their own interpretation of this decision, applying it to cases relating to Section 296(2) of the Penal Code and others under the Sexual Offences Act, presumably assuming that the decision by this court in this particular matter was equally applicable to other statutes prescribing mandatory or minimum sentences. We state that this implication or assumption of applicability was never contemplated at all in the context of our decision. While it is regretted that the report was not filed timeously and these directions not issued immediately, there can be no justification for courts below to take the course that has now resulted in the pitiable state of uncertainty The appellants whose sentences were confirmed by the High Court and the Court of Appeal have returned to the magistrates' courts, where without reference the decisions of the two superior courts have had those sentences devised. The magistrates' courts have also, in some instances, entertained applications for resentencing in murder cases, clearly without jurisdiction. Likewise, some appellants whose appeals under various statutes prescribing mandatory or minimum sentences that are pending hearing determination, either in the High Court or in the Court of Appeal, have also had their sentences revised by the Magistrates' Court without disclosing the fact that pending appeals exist in the Supreme Court. In addition, there is no harmony in the revised sentences by the courts. The sentences which have been enforced after the sentencing hearing range from commutation to the period served, probation, reduction of sentences to some specified period, or the preservation of the maximum sentences. It has been argued in justifying this state of affairs that by paragraph 48 of the judgment of this court, or indeed the spirit of the judgment as a whole, the court had outrun all minimum sentence provisions, and that although Muruatetu specifically dealt with the mandatory death sentence in respect of murder, the decision's expansive reasoning can be applied to other offenses that prescribe mandatory minimum sentences. Far from it, as paragraph 48 is clear, and it states, Section 204 of the Penal Code deprives the court of the use of judicial discretion in a matter of life and death. Such law can only be regarded as harsh, unjust, and unfair. The mandatory nature deprives the court of legitimate judicial exercise in appropriate cases. Where a court resents to mitigating circumstances but has nonetheless to impose a set sentence, the sentence imposed fails to conform to the tenets of the fair trial that accrue to accused persons under Articles 25 of the Constitution, which is an absolute right. Reading this paragraph and the judgment as a whole, at no point in reference is reference made to any provision of any other statute. The reference throughout the judgment is only made to Section 204 of the Penal Code, and it is the mandatory nature of death sentence under the section that is sent to deprive the courts of their legitimate jurisdiction to exercise discretion and not to impose the death sentence in appropriate cases. The ratio decidendum in the decision was summarized as follows in paragraph 69, and I quote, consequently, we find that Section 204 of the Penal Code is inconsistent with the Constitution and invalid to the extent that it provides for the mandatory death sentence for murder. For avoidance of doubt, this decision does not outrun the death penalty, which is still applicable as a discretionary maximum punishment. We therefore reiterate that this court's decision in Muruatetu did not invalidate mandatory sentences or minimum sentences in the Penal Code, the Sexual Offences Act, or any other statute. Likewise, our order set out in the previous paragraph specifically directed the Attorney General to prepare a detailed professional review in the context of the judgment with a view to setting up the framework to deal with sentence rehearing, cases similar to that of the petitioner's hearing, and no other case. We stated fairly, clearly too, at paragraph 111 of the judgment, the extent to which our holding was applicable. And this is what the court stated, I quote, it is prudent for the same court that and this matter to consider and evaluate mitigating submissions and evaluate the appropriate sentence befitting the offense committed by the petitioners. For the avoidance of doubt, the sentencing rehearing we have around applies only to the two petitioners herein. In the meantime, existing or intending petitioners with similar cases ought not to approach the Supreme Court directly, but await appropriate guidelines for disposal of the same. The Attorney General is directed to urgently set up a framework to deal with sentence rehearing of cases relating to the mandatory nature of the death sentence, which is similar to that of the petitioners in this case. Further, at paragraph 71 of the judgment, the court nullified paragraph 6.4 and 6 to 6.7 of the Judiciary Sentencing Policy Guidelines, which were to the effect that the court must impose the death sentence in all capital offenses in accordance with the law. In view of our holding in the judgment in question, those paragraphs were no longer applicable. It should be apparent from the foregoing that Muruatetu cannot be the authority for stating that all the provisions of the law prescribing mandatory or minimum sentences are inconsistent with the Constitution. It bears restating that it was a decision involving the two petitioners who approached the court for specific reliefs. The ultimate determination was confined to the issues presented by the petitioners and as framed by the courts. To clear the confusion that exists with regard to the mandatory death sentence in offences other than murder, we direct in respect of other capital offences such as treason under Section 43, robbery with violence under Section 296(2), and attempted robbery with violence under Section 297(2) of the Penal Code that are challenged on the constitutional validity of the mandatory death penalty in those cases should be presented and argued before the at which a similar outcome as that in the case may be reached. Murwatetu, as it now stands, cannot directly be applicable to those cases. To that extent, relevant to the matters under review in these directions, the Attorney General, in his report, which we have received, together with the task force, recommended that, and I quote, A, life imprisonment be substituted where the Penal Code previously provided for the death penalty with the option of life imprisonment without parole for the most serious of crimes. And if not abolished, the death penalty shall only be reserved for the rarest of rare cases involving intentional and aggravated acts of killing. B, all offenders subject to the mandatory death penalty, including those convicted and sentenced prior to 2010 Constitution, who are serving commuted sentences, will be eligible for resentencing, including all offenders sentenced to death, as at the time of the decision, which was made on 14th December 2017. C, where the appellant has launched an appeal against conviction or sentence, the appellate court must, at any stage before judgment, remit the case to the trial court for resentencing. We note that the other recommendations in the task force report go beyond the terms of the orders of 14th December 2017 and deal, for example, with matters that are in the legislative province or parliament or in the court's exclusive jurisdiction and judicial discretion. The appellants in this matter, the two petitioners, we have since learned were presented before the High Court. Their resentencing was heard. Therefore, we make no further comment on them. They have already benefited from this judgment. Having considered all the foregoing and to obviate further delay and avoid any further confusion, we now issue these guidelines to assist the courts below, and we do so as follows. 1, the decision of Murwatetu, and these guidelines apply only in respect to sentences of murder as provided for under sections 203 and 204 of the Penal Code. 2, the judiciary sentencing policy guidelines to be revised in tandem with the new jurisprudence enunciated in the Murwatetu case. 3, all offenders who have been subjected to the mandatory death penalty and desire to be hand on sentence will be entitled to resentencing hearing, where an appeal is pending before the Court of Appeal or the High Court. They will entertain an application for resentencing upon being satisfied that the appeal has been withdrawn. In resentencing hearing, the court must record the prosecutions and the appellant submissions under section 329 of the Criminal Procedure Code as well as those of the victims before deciding a suitable sentence. 6, an application for resentencing arising from a trial before the High Court can only be entertained by the High Court, which has jurisdiction to do so, and not the subordinate courts. 7, in the rehearing sentence for a charge of murder, both aggravating and mitigating factors as the following will guide the court. A, age of the offender. B, being a first offender. C, whether the offender pleaded guilty. D, the character and record of the offender. E, question of offense violence. F, manner in which the offense was committed. G, the physical and psychological effect of the offense on the victim's family. H, remorsefulness of the offender. I, the possibility of reform and social readaptation of the offender. And J, any other factor that the court may consider relevant. Where the appellant has launched an appeal against sentence alone, the appellate court will proceed to receive submissions on resentencing. Lastly, these guidelines will be followed by the High Court and the Court of Appeal in ongoing murder trials and appeals. They will also apply to sentences imposed under Section 204 of the Penal Code before the decision in Muruatetu case. These are the orders of the court, signed by all the 7 of us justices of the Supreme Court. Thank you very much.
Most obliged.
Most obliged.
Thank you. That brings us to the end of this case. And we will proceed with the other matters as per the course list. I will exit, and I think even the Deputy Chief Justice will exit the court and leave my sister and brother judges to proceed with the other matters in the course list. Thank you very much, and have a very good day.
Your Ladyship, President of the Supreme Court, before you exit, I don't know whether you can hear me.
Yes, I can, Senior Counsel.
Sorry, Your Ladyship, Professor Jenda. I've been unable to join, and even when I was successful a few minutes ago, I cannot be seen. My camera, I'm not able to I can see the court, but I cannot be seen. Your Ladyship, I just wanted to apologize. I was holding brief for Mr. Kioko Kilukumi and Mr. Fred Ngatia in this matter for the petitioners.
Thank you very much, Senior Counsel. Your presence is noted, and we apologize for the technology problems you have encountered.
Yes, thank you very much. And but I followed the judgment. Thank you so much.
Yes, thank you. We will now exit from the plenary and leave my brother, Justice Ibrahim, to take over the proceedings. Thank you.
Thank you.
Thank you, CJ. Thank you, DCJ. Kevin?
The next matter in the course